Hey guys, it's Kathy. I hope you guys are well today. It's Monday, so I already know you're not, but you can pretend that you're well today. I got some angry clips, angry clips. That'll help you get through your day, make you feel better. I don't know. Do angry clips make you feel better? Oh, and then also we're gonna go to Africa to see a court case there. But first, we're gonna start with an angry mini male Karen. Um, And I thought I was going to just leave it at this one because he's very angry. But the very, very next case, the judge gets angry and goes off. So I just recorded both of them. So let's get started.
Good morning, Mr. Eschbach.
Morning.
Mr. Eschbach, I have two charges, a charge of resisting arrest and a charge of disorderly conduct that are both pending for you. You have the opportunity, if you'd like, to speak with a prosecutor. It doesn't sound like from the notes you just said that you're not really interested in talking. Is that correct?
No.
So you have the option of pleading not guilty to those charges and setting them for trial. If you wanted to apply for the public defender, you could apply for the public defender, or you could hire counsel. How would you like to proceed?
I don't even know what the hell I even did wrong to even get those charges.
Do you want to take a look at the reports or have me look at them and tell you what the allegations are?
I haven't looked at it. Nobody gave me any paperwork on as far as what the complaint was. Nobody's even given me a reason as far as.
Let me look at the reports and see if I can summarize why you've received those charges for you, okay? These are just reports. They're not proof of anything, but they are reports as to what the officers might testify to as to why you've committed these offenses. So that'll at least give you some perspective of what they say. Will that help?
Sure.
Give me a moment.
I think this is Colorado, and the judges are as nice as they are in Washington State. They're like kindergarten teachers.
Okay, so the report basically says that the officers came to talk to you at the library. They asked you for your name, that you wouldn't give them your name. That's the factual basis that they would perhaps use to prove that you're guilty of disobeying a police officer order or obstruction of police. And then the other charge that's disorderly conduct. And then resisting arrest. Resisting arrest, they said when they went to put you into custody, you pulled your arms away. So those are the allegations. They're just allegations at this point. You're not guilty of anything until the prosecutor proves that you're guilty or until you plead guilty to a charge. So a couple of different ways that you could proceed right now. If you want to plead not guilty, you could do that and set it for trial. If you'd like for me to consider appointing the public defender, we could have you fill out an application to see if you qualify for the public defender. Those are two ways that you could proceed right now. You've come to court, which I appreciate you coming to your court date. So you're not being arrested or anything of that nature. I just want to move the case to the next step for you.
I understand that. So you're telling me that I have been arrested just because I didn't give an officer my name?
That's the starting point, yes. That's why they were going to take you into custody, because that you wouldn't comply with them trying to give you the summons. And so they decided that they were going to take you into custody. That's what I've got in the report.
So what started all of this?
It started with an individual who allegedly overheard you saying that you were going to harm somebody. And so then he called the police, the police came, he identified who the person was, which was you, and then they approached you and asked for your identification. And it says that you refused to identify yourself upon request and told officers to leave you alone. And then it says, I advised Eschbach he could give us information or be placed into custody. And since you wouldn't give them information, your personal information, they decided to take you into custody. And then from there, you resisted by pulling your arms back. So that's their allegation in the case. Like I said, they have to prove both charges, disorderly conduct, and they have to also prove resisting arrest. And that's what they would do at trial by presenting evidence from the officers. If you'd like to have a lawyer represent you, you want to be considered for public defender representation, we could start with that first step of you applying.
Okay, well, the arresting officer's a lying sack of shit. So that's a lie, because I gave you my identification and everything, so you lied right there. And first off, is this only one person we're talking about?
All I have is the report. It says one person contacted the police. That's
one person. And what is there any other like video, like audio recording, anything like that says in there for probable cause of arrest?
I don't know about that. Nothing in the file that talks about videos or audios. So that would be up to the officers and the prosecutor to determine what other evidence they might want to provide to the court if the case goes to trial. That's why I'm giving you the opportunity, if you'd like, to apply for the public defender, and then the public defender can represent you in conversations with the prosecutor, can secure the police reports. If there's videos or audios, they can ask for discovery. You can do that as well on your own, but if you want to have a lawyer represent you, I can consider appointing a lawyer.
Whatever gets this done faster, I don't care.
Well, the speed of it isn't really the issue for me to be concerned about. It depends on how you want to proceed. If you plead not guilty, then we're going to set it for trial. If you want to wait to plead until you have the opportunity to have counsel represent you.
I'm straight on pleading not guilty.
And would you like the public defender to assist you in your case?
As a matter of fact, I don't even know what the hell's going on or why I've been even charged. Bring more people along in this. Sure, why not? Bring more people. Let's crack the heads while we're at it.
Let's have you apply for the public defender. Robert, can you give him the
bunch of crap.
What I want you to do is, if you can watch your language for me a little, all right? I'm not trying to come down on you either way. I just would like for this process to go smoothly, all right?
Okay, there we go. Kindergarten teacher judge. A lot of judges won't deal with that. They will. And it's like you're visiting your grandma. You know, if you sprinkle when you tinkle, be a sweetie and wipe the seedy, dear. That's how these judges are. It's crazy. And what makes it crazy is what happens in the next case, because he is literally like a kindergarten teacher judge.
Robert's going to give you the application. You can fill that out, it basically just is financial information, so I can make a determination as to whether you're eligible for public defender representation.
Simple. Homeless, no job.
Put that on the application. You're likely to be awarded a public defender, okay?
I don't have a pen. Nobody gave me a pen.
We'll grab you another.
Nobody gave me a pen. Because I didn't sign anything. That's how nobody gave me a pen.
Angry.
Hang tight for a minute. Robert's going to get you a pen. We'll have you fill out the application, and then we'll go from there. In the meantime, let's go ahead and call the Justin McGarity case. Is Mr. McGarity here?
Yes, sir.
Go ahead and have a seat.
Your Honor, his attorney has not appeared yet.
I'm just going to be pleading guilty.
All right, it was scheduled for trial. I know I continued the trial at the last court date. So you've indicated that you want to plead guilty to the charge. Is that correct, Mr. McGarity?
Yes, sir.
The charge, there are 2 counts pending. Let me just take a quick look and see what we've got. I think the registration, or the other charge was dismissed, so there's just 1 count left pending, which is an insurance charge. When you plead guilty to this charge, Mr. McGarity, you're giving up your right to trial. Do you understand that?
Yes, sir.
Are you doing that voluntarily?
Yes, sir.
Is anybody forcing you to plead guilty?
No, sir.
Are you under the influence of any medications or drugs or alcohol?
No, sir.
Do you understand the charge of failing to have evidence of insurance?
Yes, sir.
Do you agree that there's evidence to support that charge?
Yes, sir.
You're doing this without the benefit of a lawyer. Are you comfortable going forward without a lawyer?
Yes, sir.
And you understand a lawyer might do a better job of representing you than you do representing yourself.
Yes, sir.
I am going to find it's a free and voluntary decision to plead guilty. It is to the charge of failing to have evidence of insurance, which is a violation of section 1409 of the Edgewater Municipal Code, allegedly occurring April 3rd of 2023 at 26th and Harlan. How do you plead to that charge?
Guilty.
Accept the guilty plea. Ms. Penalosa, any comment? I do believe the defendant does have insurance now. I have a document in front of me that shows insurance went into effect on September 14th of 2023 and is valid through January 27th of 2020.
Yes, Your Honor, there are several things. First of all, as the court is aware, we were set for trial a few weeks ago, and Officer Stakely was on overtime at that time under the ruse of saying he already hired an attorney but could not recall the name. The court granted him a continuance. He reset it for trial. He has not informed us that he was going to plead guilty. And again, Officer Stakely is here on overtime, so I request the additional $50. And I also have evidence that his, this is the most recent driving history, and he's had a prior no proof of insurance out of Lone Tree, and his license is suspended. If I could approach the court.
Yes, please. I was going to look at my own documentation, but whatever you have, I'll take a look at. Thank you.
So, Your Honor, based on those things, the fact that Mr. McGarity represented to the court he had hired an attorney, the fact that he has had this set again and inconvenienced the police department, which is overextended, and the fact that he has a prior, very recent no proof of insurance, I would ask you to impose the maximum fine.
Okay, thank you for that. Ms. Penalosa. Mr. McGarity, do you want to address any of the comments that were made by Ms. Penalosa?
Nope.
Good job. Good job.
Is this insurance that you provided to us through Dairyland Insurance? It says went into effect on September 14th. Is that still valid?
Yes, sir. I can pull up the insurance if you'd like as well.
And I've got the documentation here. I just wanted to double check that with
Okay.
you.
I have it on my phone too.
All right, so Ms. Penalosa, I'm not seeing another offense.
I fixed my license already too. I do
Let me
Florida.
just check with her first, and then I'll give you a chance to comment as well.
Sure.
What I show here is that there was a financial responsibility suspension that occurred, but it doesn't show a prior no proof of insurance violation. Do you want to comment on that? Shows an expired temporary permit, and then driving a motor vehicle off the
Well, Your Honor, if you look at
restraint, there's a restraint violation from earlier in 2023, and then a speeding charge from 2000.
in Lone Tree,
Elbert County, so in Douglas County, so that's all I see here. But there's nothing on this that shows a no proof of insurance violation in the past, which is an aggravating circumstance, but I want to make sure that
but isn't the no proof of insurance the financial responsibility?
there can be various reasons why someone gets suspended for financial responsibility under the state code. It could be for somebody who failed to pay a fine.
Well, I mean, the defendant's right here, Your Honor.
But I can't force him to make statements. He has a right of
Well,
elocution.
the court can't ask people statements about their record?
No, I cannot. It's sentencing. I can't force someone to make statements to me.
I mean, I'm okay with
I'm
it.
surprised that you wouldn't know that, Ms. Penalosa. I can't require someone to make comments. No, I give everyone the opportunity, but a defendant has a right to remain silent. He can plead guilty and still remain silent. Are you surprised by that? You're looking very...
Yes, I am.
So, under the state constitution, the United States Constitution, you don't understand the right to remain silent?
I understand the right to remain silent, Your Honor, but I believe that courts do sternly ask defendants questions about things like that.
And if someone chooses, when I ask him if he wants to make a comment, he says no, I can't force him to make a statement. So I don't know where you went to law school where you're going to get this idea that I can force him, but I'm getting a little bit tired of you acting put off for the officer's benefit as somehow that the judge is doing something wrong. I'm letting him choose to whether to give me a comment. When you have provided me a document, Ms. Penalosa, you need to know what the document means. You can't just hand it to me and say, ask the defendant. That's not appropriate for me to do. If you want to present evidence during your conversation with the court and your arguments regarding sentencing, feel free to do so. But I do not appreciate you acting like somehow I have the authority to force someone to say something to me. I'm not pleased with the fact that he came into court a month ago or 3 weeks ago and said that he had a lawyer. I understand your frustration with that, but that does not give me the right, no matter how frustrated I am with him, to force him to make statements today. I can impose penalties. I can't force him to make statements. Any comments that you'd like to make?
No.
Where did that come from? Oh my
All right.
God.
The charge that you've pled guilty to, Mr. McGarity, is a no proof of insurance charge. Your record is somewhat aggravated. It's not a completely aggravated offense. You do have insurance now. So I'm going to impose in this case a $500 fine. I'm going to suspend $200 of that fine. There's a $300 net fine. I'm also imposing a I'm imposing a surcharge based on the $300 fine, which will be a $75 town surcharge, $25 in court costs. The prosecutor did provide me with documentation from the state or from this municipal code that says in any case set for trial where the defendant fails to appear in court or requests a continuance on the appearance date, additional costs shall be assessed for each such failure to appear or continuance granted. And that should be $50. So there was one prior request for continuance. I'm going to impose that cost of $50, which leaves you with $450 to pay in fees and costs. Can you pay that today?
I can pay it on next week, Thursday.
Can you pay anything today?
Not today, no.
I'm going to give you a court date, which is November 21st. $10 a.m.
Your Honor, if I pay prior, do I need to still go?
If that balance is paid in full by 10 a.m., you will not have to be back in court.
Okay.
$450 is the balance. Do you have any questions for me, Mr. McGarity?
I could just talk to him about how to pay.
Your court date out front.
Okay.
Paid in full, you don't have to come back to the court.
Okay, thank you.
Thank you.
Am I free to go?
You are. Let's recall Mr. Eschbach's case. Mr. Eschbach, did you fill out the request for the public defender? Yeah, why don't you bring that forward?
In a few seconds, there'll be a tiny technical glitch, but don't worry. It's just a second.
Thank you, sir. All right, Mr. Eschbach, it says that you do not have any income. Is that correct?
Yeah.
All right, and you are without a home.
Yeah.
All right, I'm going to find that you're eligible for the public defender. We're going to reschedule you for a court date to come back when he can meet with you, and then he can go over your case with you. He'll be able to get copies of the reports. If there are videos or audios, those types of things, he can look into those and get those for you and share them with you. He can also discuss with the prosecutor how a way to resolve the case with your permission. And then if you decide to set your case for trial, he can represent you at trial. Does that all make sense to you? You're nodding your head yes. Do you have any questions for me?
No.
Okay, Robert, do we know when our public defender is going to be back?
We don't have him. He will be here on December 5th.
Okay, so we're going to reset you for December 5th.
All right.
And we'll do that at 10 a.m. Right through those doors. I'll get you your court date.
Popeville, I'm pretty sure it's in Colorado, that this court. And this court, so I don't get a lot of content from this court because he really is like a kindergarten teacher. And nobody ever really gets too wild. You know, he doesn't jail people hardly ever. And, you know, he reduces all fines, he reduces all sentences, almost always to time served. And, you know, that's just how it goes. But this courtroom, like you can picture like all the justices up there, you know, for a huge trial. You can picture that easily. But then you can also picture with that wavy E for Edgewater, like a I don't know, like a meeting room in a corporation, a big corporation or something. I don't know. This courtroom just is conflicting looking at it. You don't understand what it is. And you have people here with traffic fines and a kindergarten judge. But we're gonna leave Colorado. We're going somewhere else, but don't worry, everybody here is still angry. Very, very, very angry.
He also has an aunt who lives here. He's hoping that he'll be able to live with her whenever he gets out of custody. That being said, he was employed prior to his arrest, so he's not worried about finding a roof over his head, Your Honor. He thinks he could find a place on his own if he's not able to stay with his aunt. Your Honor, as far as work, he was working at a barber shop called Slide Edge. He is a barber, and he knows that he can go back to this job. So he's got a good income waiting for him. As far as education, he graduated high school and, of course, graduated from barber school. Your Honor, he has been unable to pay this bond now for about 30 days. He just essentially doesn't have anyone out with him at this time. He's hoping to get the signature today so he can get out of custody.
Hold on.
It's a problem with Chase. He wants you to let him know that he have to report on his probation. He will have to report for his mental health evaluation, and then once he completes it, it'll go non-reporting. So he's saying that he didn't hear that from you.
I ain't coming to see you about no probation. That's it. I've been telling you that. Listen, stop. I mean, please, stop. What's up?
Judge Panos.
Yes, sir.
I think he was unclear that he didn't hear you tell him he got.
You didn't say that, man.
Okay, listen.
Hold on. Let Deputy Mitchell speak for a minute so I can understand what's going on.
Listen. He was unclear that he didn't know that he had to report to probation. So you could advise him. I think he may listen.
I ain't got to report no probation. You didn't say that. The lawyer didn't say it. When you bring me back here, act like I got a report. You didn't say that about report to no probation. You said plead guilty or criminal trespass. You didn't say that about report. You said 12 months time served and that shit, man. I let people bring me here like I can't remember what you said. You didn't say about no report.
This is Mr. Williams, correct?
Mr. Williams.
That's all.
Hold on, Mr. Williams, hold on. First of all, I said non-reporting probation.
All right, that's it. It's over.
But now listen. Hold on. But what you agreed to.
Listen. You're
But what I understand you and your attorney agreed to was a mental health evaluation. So probation got to be.
I already have one. I already have one in Cab Alert. I already have one in Cab Alert. You know what I said?
Well, then all you're gonna have to do. All right, if you don't. All right, so if you did the mental health evaluation, all you're gonna have to do is report to probation one time and show them proof of that, and then it becomes an unreported.
You didn't say all that, but I'll bring the ticket down there next time. The doctor, I'll make sure. To make sure everything gets back up on my body, that you shouldn't from me. You had to check me, man. And there's something wrong with my body, man. I don't know who you are. I would please.
Judge, I think it's gonna be kind of hard for him to get down here because he is homeless. So
I had to want to pay.
Yes,
I don't know if he'll be able to get back to me.
Judge, I did talk to Mr. Williams about the mental health evaluation, but if that would require him to report to probation and he would not be able to make it there due to his homelessness, I would just ask if Your Honor would reconsider that condition.
Well, what's the state's position on this?
Your Honor, if he is in fact homeless, and already has a mental health violation, and the probation officer doesn't want to meet with him, and we're not caretakers for the mentally ill. The jail is not a caretaker for the mentally ill, so I don't care what the court does.
All right, Ms. Clark, I'm going to skip the mental health eval. I'm just going to make an unreporting. Mr. Williams.
Yes.
If I catch you a quick trip, you're going to be in jail for a long time.
Okay, but please,
I'm just telling you. That's going to be my Santa Claus gift to you.
Yeah,
all right, you can have a seat. You don't have to do the mental health thing. All right, let's see. Where were we?
So that's how that court almost always goes. The prosecutor is like, I don't care. I don't care. This is the law. He's trespassing. And the defender's like, oh, mental health. The judge is like, these are the rules. If you break the rules, you're going to jail. And the prosecutor lots of times will say, well, he had, 7 warrants in this case and 4 failures to appear. The judge doesn't care. He's like, I don't care. I'm giving him a personal bond, and if he doesn't come to court, I'm going to throw him in jail. That's just how it's going to go. He doesn't care what other people think someone's going to do in the future. He's going to give him a personal bond, and then he's going to throw him in jail. And that's just the way it is in that court. It's pretty funny. All right. Now we're going to go not Wisconsin. Washington State, I think. We're going to Washington State, and, for a civilian who thinks he's a lawyer.
All right, sir. Please state your name and date of birth, please, for the record.
Wyatt Losey, February 16th, 2005.
Okay. So, Mr. Losey, you are a gentleman before the court also on a contested hearing. You've heard me talk to the other folks about contested hearings. When we start a contested hearing, I can either find the infraction committed or I can dismiss. There's no middle ground. There's no halfway. We don't do second bites of the apple. You are eligible in your case as well for what's called a deferred finding. In particular, for a younger driver, it would mean that if you had no other non-moving violations in the next year, this charge would not go on your records, would not get reported to your insurance company, and after a year would be dismissed. Instead of proceeding with the contested hearing today, would you like to instead do a deferred finding?
No, I'd like to continue with the contested hearing.
Okay.
Bad idea, dude.
All right, what's going to happen, sir, is I'm going to read the officer's report into the record. I am then going to swear you in. You can provide any testimony you choose to, okay?
Okay.
All right, this is a report from Officer Romero of the Battleground Police Department. It says Unit 1, a 2004 Mitsubishi bearing Washington plate CGA 0201 was traveling north from south on Southwest 10th Avenue, approaching Southwest Eaton Boulevard. Unit 1 collided with the rear of Unit 2. The impact caused Unit 2 to collide with the rear of Unit 3. I spoke to the driver of Unit 1, Wyatt M. Losey. Driver of Unit 1 admitted he was on a cell phone, using his cell phone and not paying attention to the road. Driver of Unit 1 said he noticed the vehicles ahead of him slow down for traffic, but he did not have enough time to come to a complete stop and rear-ended Unit 2. Driver of Unit 1 was given a traffic infraction for using personal electronic device while driving. I certify or declare under penalty of perjury and the laws of the state of Washington, the statements made herein are true and accurate, and I'm entering my authorized user ID and password to authenticate it. Officer Stephen Romero, 6232. All right, Mr. Losey, raise your right hand. Do you swear and affirm the testimony you're providing today is true and accurate to the best of your ability?
I do.
Okay, lower your hand. Go ahead.
So when the officer had asked me that question, I did not answer that correctly because I was in shock because he had asked me maybe 10 minutes after I had just impacted. I was not using a personal electronic device at the time. It was in my pocket. I was on a Bluetooth call, which according to RCW 4661.
Do you have any proof you're on a Bluetooth call?
What?
Do you have any proof you're on a Bluetooth call? Any documentation that shows it was a Bluetooth call?
On me? No.
All right, go ahead.
I was on a Bluetooth call. My phone was in my pocket, and I, did not notice until it was too late and had not enough time to slow down. However, according to RCW 4661672, use means holding a personal electronic device in either or both hands, having your finger on the device, or specifically using your hand or finger to post, send, read, view, access, browse, transmit, save, or retrieve an email, text message, instant messages, photographs, or other electronic data. I was doing those. I was not watching a video on a personal electronic device. It was in my phone while I was speaking through a speaker right behind my steering wheel.
Any other testimony?
No.
Any witnesses? Anybody else in the car?
No one else was in there.
All right, I am going to find the infraction committed, impose the fine of $145. I think your statement to the officer at the time was accurate. I think you probably were using your phone. It's your word against the officer's word. Clearly you caused it. No, not unless you're a witness. Were you in the vehicle with him at the time? Then I don't think you have direct testimony. He may have a Bluetooth. I don't know if he was using a phone or not. He told law enforcement he was. I have one person saying one thing and one person saying the other with no proof. In particular, as there was a 2-vehicle accident caused by whatever you were doing in the vehicle. I think this is extremely serious. The conduct, you need to pay attention when you drive. I have no evidence that beats the preponderance standard that shows that you were not operating a vehicle while using the device, in particular, if that's what you told the officer 10 minutes after the accident. I agree that you probably were in some manner of experiencing some manner of shock, but that said, you've had weeks to reflect now on what happened, and it certainly is better in your circumstances to be on a Bluetooth device. So I don't think it makes it more credible, in particular if there's no witnesses, no proof, and it was the statement made contemporaneously to the officer at the time of the incident. I'm going to find the infraction committed. You do have the ability to appeal my decision to the Superior Court in Clark County. Thank you.
Oh, he's appealing. You know he's appealing. He's going to find more legalese words in his next one because the judge didn't go for this one. Okay. All right. So that was someone defending themselves badly. Next, I'm going to go to a defense lawyer who infuriates me. Really bad defense lawyer. And you'll see why.
Okay, Mr. Wilson, if you'd come up with your attorney, please. All right, and Mr. Wilson, if I could have you state your name and date of birth, please, for the record.
Christopher Wilson, December 30th, 1980.
This matter is cited in for a pretrial release violation. I did review the violation and assign this on for today. I think what's probably best is I'll hear from the city, Ms. Carmy first, who's looking to revoke Mr. Wilson's release. I'm going to hear from Mr. Sowards on behalf of Mr. Wilson, and then we'll have a determination made. Go ahead, Ms. Carmy.
Yes, Your Honor. In addition to what we filed, and I guess we would first let the court know this was our third motion alleging pretrial violations. We've had significant issues since arraignment, frankly, with Mr. Wilson adhering to non-use of alcohol. The reason we filed the most recent motion is somewhat twofold. I mean, number one, obviously there is enough more likely than not evidence of alcohol use with the PBT done at the scene, the officer's observations of alcohol use and intoxication. But somewhat more concerningly to this court is that children are being affected by this, making the calls to law enforcement, begging for help, essentially. So we understand that Mr. Wilson may come here and ask to be placed back on scram, which is where we originally started in his case. But the city right now believes that for community safety, for the safety of Mr. Wilson himself and his family, and somewhat punitively for the number of pretrial violations we've had, we are asking for release to be revoked, 15,000 bail set upon posting of that bail or release that scram be reimposed.
Mr. Sowards.
Thank you, Your Honor. I know that Your Honor is aware of the case at hand, his connection to his wife's case, Mrs. Wilson, and their daughters. I've also gone through the report, and I would highlight to the court a number of contacts referenced in the report, specifically 930, no issue of intoxication. That was the first issue. October 5th, a visit by the officers, no issue of intoxication. October 7th, visit by police officers, no issue of intoxication. But on the September 30th and November 14th, those are the dates in question that the prosecutor picked out of the report. Now, in this case.
Oh, come on. Imagine this was a murder trial, okay? It's a murder trial. And the defense attorney comes up and says, yeah, okay. All right, he murdered someone on October 31st and November 14th, but he didn't murder anybody on September 2nd. He didn't murder anybody on November 4th. The prosecutor's just picking out the dates where he murdered someone and doesn't look at all the other dates where he didn't murder anyone. What kind of defense is that? It's outstanding. I mean, I heard that and I was like, you got to be kidding me. You can't say that. But it gets worse. Like, the defense attorney doesn't get worse. He's bad, and that's fine. This guy, what he did was really bad.
Your recommendation to go through first, I would argue that it is not proper in a release condition to be punitive. Release conditions are for ensuring presence at trial and the following of conditions. The goals of the court today should be in that respect. We know that there are children involved, but again, this is not family court. However, for the court's information, as Your Honor is aware that Mr. Wilson has gone through a difficult separation and his function as a single parent. Within that family unit, the youngest daughter, the parties are having her now reside with the mother up in Kenmore. And the older daughter is now residing primarily with very close friends in Richfield. But she and her father are still texting, talking, and working through some of these issues caused candidly by his drinking. I don't think Mr. Wilson's there. For the prosecutor's recommendation of a $15,000 bail, Your Honor, bail in that type of environment is to ensure presence. Your Honor is aware Mr. Wilson has never fled the beat court, at least to my knowledge. He's always been present. And in fact, as shown by this report, has always been cooperative and compliant with officer's request. You'll note that the November 14th incident resulted in a request for a portable breath test. And then he complied. So in this circumstance, the release condition at issue is the consumption of alcohol. Bail, candidly, Your Honor, unless you're going to keep him in jail, and if that's your intent, a bail of, $150,000. But the bail itself is not going to address what I consider to be the real issue before the court today. My client is in agreement that the scram bracelet is there. Since his last court appearance, he has now the ability financially, which was the issue before, to pay for the scram. I went through the report with my client, and I would like to note that although it was a very poor decision with respect to the November 14th, when he brought the daughter home from school, there was consumption of alcohol between that at home and his contact with the officers that resulted in 0.25 portable breath test, PBT reading, that may have had some mouth intoxication. We don't know the time between his last drink and that. My client he can't deny the use, he relapsed. But again, we would note that during this family law number of incidents, there were a number of contacts where the intoxication was not an issue, but certainly there were the two, and there's no way around that. So rather than revoking and a bond that will do nothing more than add a couple of dollars to affordable bail bonds budget this year, we would ask the court to simply use the scram bracelet, which again, he has arranged the funds, he can now take care of that, and that would provide the 24/7 monitoring needed. I don't know if Your Honor wants me to go into the father-daughter relationship issues. My client, the way they're presented in the report, would have issuances, but this is not custody. This is about my client drinking in violation of Your Honor's. So he is here to answer your questions and fully willing to use scram, possibly in addition to some type of enhanced monitoring. I do not know. But with that, we would let Your Honor ask the questions I'm sure you have.
Well, I'm not going to ask your client questions, Mr. Sowers. Your client has a right to remain silent. Certainly the underlying allegations of this incident when it first takes place, February, March of last year, is extremely dangerous driving, impacting a number of members of the community outside of Mr. Wilson's family. If I'm recalling this correctly, I'm just going to briefly look at the probable cause statement, because I certainly do not. If this is a different case that I'm thinking of.
This was his truck going into the neighbor's fence in the driveway before hitting the public road. Underlying charges, negligent driving based on.
Well, I understand. I'm just taking a look. So March 2023, I imposed scram as Mr. Wilson's release condition. He did not abide by my condition. In fact, he took off for over a month and didn't have any manner of release condition in place. The allegation at the time in the probable cause statement, and I wanted to make sure, was not only damage to people outside his family, but the endangerment of Mr. Wilson's own children. That is very strikingly similar to the allegations that we have in front of this court right now, that he's picking up his kids from school impaired. I dealt professionally with clients over a long period of time that have issues with alcohol. I personally find it very difficult to believe that Mr. Wilson drove sober, was accused from some spurious reason of being impaired, and then just happened to get grossly impaired. Impaired so much that most of us in this courtroom would be passed out.
Not me.
I mean, Your Honor, that would have been a misrepresentation by me. Mr. Wilson did say that he had drank before picking up his child, just had drank in addition to that. So if that was my presentation, that would be my error, not his.
So I have I have the exact same conduct then, Mr. Sowers. They have the identical conduct in that he just didn't crash this time. He still is picking up his kids from school, driving on public roads. He didn't crash this time, but this is not Bail is intended for a number of reasons. And it is intended to make sure a person appears at future court dates. You are 100% correct. But bail is called for and is paramount when there is a pronounced community safety issue. I have not seen in my 2 years on the bench, with the exception of maybe one other case, a more staring me in the face, blatant, pronounced community safety issue. Every one of these conducts that I'm seeing not only involves law enforcement being called and his kids and alcohol, but a number of them involves him driving. Every time he gets in a car impaired to go pick his kids up at school, there is probably 250 other kids who are impacted that are walking out of that same school. There's probably 250 other parents that are picking kids up from that school. There are probably 1,000 other motorists that he encounters going to and from that school drunk. So he is going into custody today. I'm going to impose bail in the amount of $25,000 because I believe the only way I can guarantee that Mr. Wilson is not drinking is if he's in the Clark County Jail. I want to be very, very, very clear. Mr. Wilson has had an abundant number of chances. If this was punitive, I would have taken him into custody on March 31st of 2023, the first time he didn't put the scram monitor on that I ordered him to do. I have been extremely accommodating, and I've been accommodating to such a point that I have endangered his children multiple times. And I will not do that again. I will not endanger his children or any other children in the community because he continues to choose to drink alcohol. Look at me, Mr. Wilson. I have been extremely patient with you. You have a serious problem, and a scram monitor is not going to solve that problem. You will be on a scram monitor if you do post bail, but I hope for your own sobriety that you detox in the Clark County Jail, you receive medical care in the Clark County Jail during that detox, and that you are stone sober for the remainder of your case. Do you understand? Now, we already have a court date forward for Mr. Wilson that's scheduled, I believe, for a readiness hearing. I need to dig back through the paperwork here. And I'm assuming at this point, we want to leave that court date set.
If I may, Your Honor.
Yes.
Given that the underlying charges are negligent driving and a hit and run unattended, I would ask that the court bring this matter back a week from today. And I think that the diversion discussions that I previously had with the prosecutor may very well be somewhat in jeopardy. And I think that, I think you're going to be able to comment. Go by that. Okay. But if we come back a week, we might be able to just resolve this case.
I am not.
We don't have this card.
Well, then we'll just leave the dates as they are and trust that Mr. Wilson can make.
Let's do this. My proposal, Your Honor, would be let's keep December 28th, which is what is set. Mr. Sowards, you and I can talk if there is a resolution reached. Either I can log in to take that resolution or, because I won't be here the next 2 Thursdays, or Mr. Busby can handle it in my absence.
Okay. You have your phone with you. Okay. Your Honor, will my client have an opportunity to call his father prior to being transported to jail?
I think he can call his father when he gets to the Clark County Jail. I think it's a standard protocol that when a person's being transported, they don't call family members beforehand. I think it's a safety issue. So we're not going to have him call anyone until he arrives at the jail. So readiness will continue for the 28th of December, 2023. That's right now going to stay on our 1:30 docket. Mr. Wilson's release conditions will be to violate no laws, notify the court of any change of address or phone number, no consumption or possession of alcohol or non-prescribed drugs. If Mr. Wilson does post bail, he'll be on 24/7 scram monitoring and intensive pretrial release. I would like the Scram monitor to be on before he's released, but I know that they can't do that. So what I'm going to write on the form here, and this is what I want to go to the jail and what I want to go to pretrial release, is if he's released and he posts bail, Scram monitor has to be on within 24 hours. I'm not giving him 5 days. This is not statutory in regards to a DUI. So within 24 hours of release, he's on the Scram monitor. I am in no way, shape, or form going to tolerate any greater amount of time. I don't care what day of the week it is. I'll have to take him back into custody if he doesn't abide by that condition. I'm at the end of the things I can do. This is just getting too extremely dangerous for the entire community. Good luck, Mr. Wilson. Thank you. Yep. All right, Mr. Lowe, you've been.
So the prosecutor did offer, before this happened, a plea where he would get deferment. And the lawyer, the defense attorney, still believes that they're going to come up with a resolution. No, you're not. That offer is gone. There's no way he's getting a deferment. None. Zero chance. So those court dates, December 28th, that'll still be there. Don't worry. They're not going to fix this outside of court. All right. All right. We've had enough anger today. We've had enough crazy in America. Let's hop on over to Africa. Now, this is a panel of judges, not one judge. And the judges are by territory or a city or whatever, however they divide it. And I don't understand everything that happens. It's a horrific case. It is horrific. But I don't understand some of the terms that they use and the resolutions that they come up with. But you understand enough. So here we go. It's just interesting.
The court will be reconstituted, and I, Justice Imani Abud, I will be recused, being a Tanzanian, and the following judgments are against Tanzania.
The audio gets better. She just recused herself because she's from that territory. But the rest of the judges are still here.
Ladies and gentlemen, the court is called to order. We'll now move on to application number 003/2016, George Lazaro versus the United Republic of Tanzania. Judge Nsebesa, you have the floor.
Thank you, Mr. President. In the matter of John Lazaro versus the United Republic of Tanzania, in application number 003/2016, is the judgment of the court delivered on 7th November 2023. The court is composed of Mudi Osako, the Vice President, Ben Kiyomoko, Rafa Ben Ashur, Suzanne Menga, Islana Chizumila, Shafika Bensaula, Blaise Chikaya, Stella I. Anukam, Dumisan Sebeza, Dennis D.R.J. judges, and Robert Eno, the registrar. In accordance with Article 22 of the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights, hereinafter referred to as the Protocol, and Rule 9.2 of the Rules of Court, hereinafter referred to as the Rules, Justice Imani Diabaud, President of the Court International of Tanzania, did not hear the application. Subject of the application regarding facts of the matter, it emerges from the file that on the night of the 31st of August 2003, at Bishesha Village, Karagwe District, the applicant and 4 others stormed the residence of his neighbor, Clemens Mbasa, tied him up, and gagged his wife when she tried to raise an alarm. He forced them to give him money from coffee proceeds, which they had recently sold. Thereafter, upon realizing that Mr. Mbasa had recognized them, the applicant killed him by driving a sword through his mouth and dragged him across the room to ensure that he was dead. The gang then turned their attention toward the deceased wife, demanding for more money from the coffee proceeds. They cut her stomach and shoulders with a machete and tied a rope around her neck. She directed them to the kitchen where they found the rest of the money. She pretended to be dead as they battered her and then fled the scene of the crime. Thereafter, the deceased wife ran outside and raised an alarm, thereby attracting neighbors to come to her rescue. Subsequently, the applicant was arrested on the same day and was jointly charged with his brother, Evaristo Lazaro, with the offense of murder. The brothers both pleaded not guilty. The third suspect, Ezra Felix, was also arrested but was not charged. The police failed to trace the 4th and the 5th as suspect. On the 10th of November 2004, the applicant and the other accused persons were arraigned before the High Court of Tanzania.
Yes. Okay. So he did say Lightfoot. He did say 2003, 2004. What happened was they murdered these people in 2003, 2004. They were in court and they got the death penalty for murdering these people. Well, now they're in front of the Health and Human Rights or something like that court, and they're basically fighting the death penalty to see if they can, just get life in prison. So they've been on death row this whole time while the death penalty is being argued. So now they're in front of this court to see if they do actually get the death penalty now in 2023.
Karagwe for plea taking. The trial commenced at the High Court of Bukoba on the 22nd of July 2010, and following a trial within a trial, the extrajudicial statement of Evaristo Lazaro was declared admissible and it was tendered as evidence. The main trial was concluded on the 6th of August 2010. The applicant was found guilty of murder and sentenced to death by hanging, but his co-accused, Evaristo Lazaro, was acquitted. On 12 August 2010, the applicant filed an appeal to the Court of Appeal, which was heard on the 25th of November 2011 and dismissed on the 28th of November 2011 for lack of merit. The prayers of the parties. The applicant prays the court to make a declaration that the respondent has violated the applicant's rights under Articles 3, 4, 5, 6, and 7 of the African Charter. Declare the application admissible. Make appropriate orders to remedy the violations of the applicant's rights under the Charter. Set aside the death sentence imposed on the applicant and remove him from death row. Amend its penal code and related legislation concerning the death sentence to make it compliant with Article 4 of the African Charter. Release the applicant from prison and order the respondent state to pay reparations as it deems fit. The respondent state prays the court to find that it did not breach Article 13(6)(a) and 107(2) of the Constitution. Find that it did not breach Articles 3(2) and 7(1)(c) and d of the African Charter. Find that the prosecution proved the case is beyond reasonable doubt. Find that the conviction of the applicant was based on the evidence which was watertight and credible. Find that the prosecution in original criminal section number 88 of 2004 and the criminal appeal number 230 of 2010 were conducted in accordance with the governing laws and procedures. Find that the sentence meted out against the accused was in compliance with the laws. Find that the decision of the High Court was not based on some serious misdirection on the point of law. Find that the Court of Appeal is not prejudiced to make review of its own judgment. Order that no reparation be awarded in favor of the applicant, and order that costs or the application be borne by the applicant. I now read the operative part, which reads, for these reasons, the court unanimously on jurisdiction dismisses the objection to material jurisdiction, declares that it has jurisdiction. On admissibility, dismisses the objection to the admissibility of the application, declares that the application is admissible. On merits, unanimously holds that the respondent has not violated Article 7(1)(c) of the Charter, as read together with Article 14(3)(d) of the ICCPR in respect of the failure to provide effective legal representation. Holds that the respondent state has not violated the applicant's right to a fair trial as enshrined under Article 7(b)(c) of the Charter, as read jointly with Articles 14(2) and Article 14(3)(e) of the ICCPR with regard to his conviction based on insufficient evidence. Holds that the respondent state has not violated Article 7(1)(c) of the Charter, as read together with Article 14(3)(a) of the ICCPR in respect of the failure to provide the applicant with interpretation services during his trial. Holds that the respondent state has violated Article 7(1)(d) of the Charter for not putting the applicant on trial within a reasonable time. by a majority of 8, 4, and 2 against Judges Blaise Chikaya and Tumisa Pintsabeza dissenting on the issue of the death penalty, holds that the respondent state is violated the right to life protected under Article 4 of the Charter in relation to the provision in its penal code for the mandatory imposition of the death penalty, as it removes the discretion of the judicial officer. Holds that the respondent state has violated the applicant's right to be treated with dignity under Article 5 of the Charter in relation to the method of execution of the death penalty, that is, by hanging. Unanimously, on reparations, pecuniary reparations, dismisses the applicant's prayer for material damages, grants the applicant's prayer for damages for moral prejudice is suffered, and awards him the sum of Tanzanian shillings 500,000. Orders the respondent state to pay the sum awarded under 9 above, free from tax, as fair compensation to be made within 6 months from the date of notification of this judgment, failing which it will be required to pay interest on arrears, calculated on the basis of the applicable rate of the Central Bank of Tanzania throughout the period of delayed payment until the amount is fully paid. Non-pecuniary reparations orders the respondent state to immediately take all necessary steps within 12 months to remove the mandatory imposition of the death penalty from its penal code, as it impinges on the discretion of the judicial officers in imposing sentences. Orders the respondent state to publish its judgment upon notification thereof on the websites of the judiciary and the Ministry for Constitutional and Legal Affairs, and to ensure that the judgment remains accessible for at least 1 year after the date of such publication. On implementation and reporting, orders the respondent state to submit to it within 6 months from the date of notification of this judgment a report on the status of implementation of the order set forth herein, and thereafter every 6 months until the court considers that there has been full implementation thereof. On course, orders each party shall bear its own course. This signed Modibo Sako, Vice President, Ben Kioko, Judge, Rafa Benashur, Judge, Susan Menge, Judge, Tujilani Chismila, Judge, Shafika Ben Saula, Judge, Blaise Chikaya, Judge, Stella Ayanukam, Judge, Tumisa Bin Sabeza, Judge, Dennis Diajay, Judge, and Robert Ino, Registrar. In accordance with Article 28.7 of the Protocol and Rule 71 of the Rules, the dissenting opinions of Judges Blaise Chikaya and Tumisa Nsebeza were appended to this judgment. Done at Arusha this 7th day of November in the year 2023 in English and French, the English text being authoritative. Mr. President, I hand down the judgment.
Okay, so here's what I think I understand. You guys just saw it all too. So this guy and his brother stormed his neighbor's house, killed him, and then what caught me up was he kept saying the deceased wife ran to the neighbor's house. And I'm sure now what he meant was she died after. I mean, obviously. But he kept saying the deceased wife did this and that, and I didn't understand what he was talking about. If she was deceased, How did she do anything? But no, she didn't get killed right away. She went to her neighbor's house and then died from the wounds. So she's deceased. And so the deceased wife goes to the neighbor's house, raises an alarm. Him and his brother get arrested in 2003. They didn't get a trial until 2000. Well, they got arrested in 2010. The trial was 2011, I think. Or were they arrested in 2003? Anyway, they had a delay for their trial, obviously. And they didn't have an interpreter there. So what they ruled, and they got charged and were going to get hung, death penalty. So what this court is saying is that, well, you have to give them a quicker trial and you have to give them an interpreter. So Tanzania, you were wrong for that. Now you have to pay the murderers money because you infringed on their human rights. Even though they were murderers and what they did was horrible, Tanzania now has to pay the money. Now, it doesn't say anywhere what happens to these two brothers. They're not going to get hung, all right? The death penalty is off the table now, so they get to live. But I don't know if, I'm assuming, and this is just my assumption, that they just, live a life sentence in jail. Or I don't know. A judge from Tanzania is going to have to re-sentence them because, they've been in jail now, 20 years or 10 years, depending on which date it was. I don't know. But it was confusing. But the death penalty was on trial there. And there's no more death penalty in Tanzania from what they said. I didn't check the website out to see if they posted it. I know I should have. I should have checked it out, but I'm sure it's there. I can't imagine that Tanzania will just not go along with the judges. That's like the Supreme Court handing a ruling down in Ohio, not following it. Actually, you never know with Ohio, do you? Okay, guys, that's all I have for now. I got more. I just have to put it together. Thank you so much for coming out today. I hope the anger makes your day go a little better. And I will talk to you next time. See you guys.